All right, we have about 2/3 of our participants. So for the benefit of the people that are here in time, we're going to get started. Welcome everybody to our, to our webinar on terminations and calculating termination packages. And we're going to include COVID-19 considerations along the way. This is kind of everyone knows this has been a strange time, but as far as us moving through this crisis, new issues and new legislation seems to pop up. So as long as our webinars remain relevant and you folks keep on wanting to hear them, we'll keep on doing them. So your host for today's webinar, of course, well, I should start with this discussion is not constitute legal advice. That's our little disclaimer to keep us free and let us say whatever we want. Myself, Darcy, I'm the CAO and Chief HR Consultant for HR Primed. HR Prime's been around for about 4 years right now. In the last year, we've more than tripled our client base, and we're coming along nicely, and we appreciate all the support from the folks in this webinar. My co-host today, joining us for the first time in our webinar series, is Steve Caron. Steve is one of our senior HR consultants. I'm very pleased to have him join us. He will be doing a slide on terminations in a union environment near the end of the formal part of the presentation, which will be a prelude for a full webinar on terminations and other considerations in a union environment, which will be coming to a computer near you soon. And of course, the mascot of HR Primed, Tar Heel. You can tell he's a little bit tired. We did not have to do the last webinar, or did not do the last webinar, begging your pardon. So Tar Heel's had about a 3-week break. So as you know, working from home can be a pretty unpredictable environment. So Tar Heel is a beagle. He may make his voice known at some point during this presentation. He's incredibly opinionated, especially about HR. You can see that he is a certified human resource dog. In the last 3 weeks since he had a break, he's also been working really hard. He just received his Bachelor of Arts in Anthropology. So you can see the designation there. We actually, last week, we did a dig in our backyard and he found a whole bunch of bones. So we're pretty happy for his latest achievement. And of course, for participating or at least registering in the webinar today, as we've been prone to do, we like to provide some type of thank you for participating. So you will be receiving an email with a discount code, which you'll receive sometime this week, I think in a few days, with a discount code for anything that HR Primed offers on our interactive e-learning platform, HR on Call, health and safety, or HR support. So let's get started with the outline. You'll see there that it says submit your questions for the live Q&A. We have about 10, 11 questions that were submitted in the advance of the webinar, so we'll be sure to answer those. By all means, as we go through the webinar, there's been a couple questions that have already come in. Please enter in any questions that you may have in the Q&A panel. This is very much what our on-call support looks like. We simply have people ask us questions and we answer them right away with the expertise that we have on our team. So all the topics we discuss, COVID-19 isn't a particular topic in this presentation, but all the topics that we discuss will be done so with the backdrop of COVID-19. So anything about terminations, layoffs, constructive dismissal, there's been a lot of recent changes lately. So we'll discuss that all with having COVID-19 considerations in thought. So the first thing we're going to touch is types of terminations. Thereafter, calculating termination packages in common law. That will be another webinar that happens closer to when we get out of COVID-19, because we can talk about that subject alone only for an hour or two. So it'll be a condensed version. A brief overview, begging your pardon, of terminations in a union environment offered by Steve. And then our friends at the Leslie Group will be joining us to talk about terminations and benefits. I believe Matthew is on the call today, and he will be your facilitator for that part of the presentation. So let's start off with types of terminations. So there's terminations with cause, which all of us are familiar with, but hopefully have not had the occasion to do too often. Termination without cause, which is far less risky and also more common in the termination world. Terminations and layoffs. So typically a termination without cause is a layoff, but because of everything around COVID-19 and the recent changes to legislation, we're going to discuss it on its own merit in this presentation. And then finally, constructive dismissal, which has taken a weird and wild twist with COVID-19 and the new legislation that came out this past week. So termination with cause, and as you can see, when you terminate somebody with cause, you are essentially shutting the door. The moment you terminate them, they're to receive no pay, their benefits cease. It's a pretty serious thing to do, and it carries with it a lot of liability, obviously. So in order for you to achieve termination with cause or go down that road, the termination, you must have either a single serious incident or a culmination of similar incidents that lead you to reach the bar that you would require for termination with cause. So you'll see some examples on the screen of single incidents: theft, defamation, workplace violence, discrimination, gross misconduct, et cetera, et cetera. You'll also see that I wrote the culmination of an appropriate progressive discipline process. So it's important to note with progressive discipline, we're not going to discuss progressive discipline in detail, but it's important to note I underline the word appropriate. There's no law in any of the jurisdictions across Canada, unless you're breaking someone's human rights or their ESA rights, that governs an employer in the discipline process. So essentially, if you were to discipline an employee, even if it was, let's say, inappropriate, the employee does not necessarily have a venue or a law which they can land on or go to make their action known that they feel that the discipline was inappropriate or undeserved. It's only at the end of the progressive discipline process, when you end up in front of a tribunal or in front of a judge, that all the steps that you took in the progressive discipline process will be examined for their merit. And I can assure you, if any one of those steps was not done correctly, then the termination for cause will not hold. So it's important to note that when you're terminating with cause and you're doing it via the progressive discipline process, the measurement will be perfection at every level of your actual process. There's also a significant risk that comes with terminations with cause. I must admit, as a client as an advisor to my clients, I remind them all the time about the bar that has to happen to reach it. The burden of achieving the bar to achieve with termination with cause lies significantly with the employer, and solely with the employer. The one thing that I'd like to note here, because you've seen on the screen when I put near cause, I have many employers that come to me and cite all the different reasons why they believe an employee should be terminated. If you don't reach the bar of cause, there's no such thing as near cause. It's not horseshoes. It's either you have cause or you don't. So you can have a list of 5 or 6 different things that you would like to terminate an employee for, but if you haven't reached that bar of cause, then you're terminating without cause. There's no in between. So one of the things about the significant risk that I try to remind my employers about is the employee has nothing to lose. So when you put something on the table, even if it's a minimum ESA, they're walking away with something and they could feel good about that, or they could feel upset but figure it's not worth it to pursue it. But when you terminate an employee with cause, and again, no pay, no benefits, you should expect a response. And that may be via court, it may be through the Ministry of Labor, Human Rights, expense, et cetera, et cetera. But the process is expensive by itself. And that's if you win. You still could actually end up in a court, lose, have to pay for your court costs, and then have to pay for the monies that would be owed associated with the termination without cause or wrongful dismissal. And moving on to the meat of this subject, in order to win, whether it be in front of a court or a tribunal, the bar you must reach is something referred to as willful misconduct. Many of the HR people, oddly enough, are not necessarily familiar with this bar. So we're going to discuss willful misconduct in a little bit of detail so you can understand what you need to do to be able to terminate somebody with cause successfully and have it hold in a court or in front of a tribunal. So the first thing, what is willful misconduct? So willful misconduct is an act or series of acts that are in combination are considered both egregious and are intentional or deliberate. So it's kind of for a short little definition, it's kind of a loaded statement, and each piece of that definition is really important. So it's not easy to prove. So establishing willful misconduct requires that you not only look at the act, which may very well be egregious, but you also have to look at the intention or purpose of the employee. If the act does not meet the definition, which is both egregious but also intentional or deliberate, then it's not going to be considered willful misconduct. So one of the examples I like to use is, and forgive me for saying it just this way, but is stupidity. If an employee does something that is inherently stupid and that ends up to turn out to be an egregious act, that by itself does not necessarily mean you've met the bar for willful misconduct and termination for cause, because in fact, that employee's actions were not deliberate or intentional. They were just a mistake in judgment. In most cases, and this goes back to what I was referring to in the last slide, most employers think that the things that they can terminate for cause are in fact not what they can terminate for cause. So for example, policy violations, general laziness, poor work ethic, poor attitude, all these things are not considered to be intentional or deliberate. So if you were to bring forth a, by itself, by the way, I'll get to the premise of this, by the way. If you were to bring forth a termination with cause for someone who's generally lazy or has a poor attitude, if you did not do so by taking that through the progressive discipline process and continually warning them and offering support and making them aware of the consequences, you'll never have a just cause termination hold up in a court. And I want to use, it's an older piece of case law, and it's actually an arbitration, but it is the best example of the willful misconduct theory about the difference between an egregious act and the bar to meet, which is also it being intentional and deliberate. So if you consider a supervisor who's worked with the company for 32 years, this supervisor thought it would be funny to set a coworker's safety vest on fire. So he didn't intentionally set it on fire. It was like kind of like tying the shoestring to your shoe and tying it on fire and it burns up and all that kind of jazz. Well, there's that really fluorescent stripe that's on a safety vest, which is highly flammable. The person didn't take that into account. Nevertheless, he tried to play a joke. The person's safety vest went up in flames, and the person ended up with severe burns and injury. The employee, as most of us in this call would naturally assume, was terminated with cause. The case went to an arbitrator, and then that decision by the arbitrator was held up in court. So the question is, what do you think happened? In this case, the arbitrator and the court ruled that the termination was excessive, that even though the action is certainly egregious, causing burns and bodily harm, it was definitely not intentional. Moreover, the fact that the employee had been there for 32 years and had no discipline on his record whatsoever made the court and the arbitrator believe that you cannot take this one snapshot of 32 years in service and say this employee is merited of being terminated with cause. But it is a perfect example because that whole thing started with a poor judgment that even though the outcome was egregious, the intent was not. So we always put these little things up here. These are the types of things that you will, as an HR professional, business owner, etc., deal with on a day-to-day basis. These are the questions that we are experienced in and have many years of executive experience in dealing with. So these are the things that we believe that you should be calling us, preferably, but most certainly whether it be another HR expert or a labor lawyer. These are the types of things that you should be getting advice on because they can cost you a lot of money. So we're going to move on to terminations without cause, and you'll see there it's the safer road. I'm highly suggestive to my clients that unless you have a slam dunk case against an employee, and you can afford it, of course, that termination without cause is typically the way to go. And there's a couple reasons for that, and we're going to go through them right now. The first is you don't need a reason. So employees can terminate without cause for nearly whatever you want and whenever you want. You simply have to be prepared to pay the amount owing. Okay, so that is a common misnomer that you actually have to provide a reason in the letter or you have to provide a reason to the employee. In fact, you have the right to terminate an employee for whatever reason you prefer. There's a few exceptions which we'll get to, but there's no criteria for which you have to terminate an employee without cause. Sound advice in most cases, and this is what I alluded to earlier, unless you have a slam dunk case for termination with cause, I'm typically going to advise my clients to terminate without cause. If you consider this, if you're an employee of 1 or 2 years, so at the 1 or 2 year mark, they're typically not eligible or would be considered worthy of getting common law, depending on the circumstance, of course. So you're looking at 1 to 2 weeks pay. If you terminate that employee for cause, even if you have it, the cost to retain a lawyer by itself to take that employee to defend yourself in a court is going to cost more than the 1 or 2 weeks pay that you would have paid the employee. So you have to keep in mind it is a business decision. It is not an emotional decision. Typical reasons for terminating with cause, just so you can have an idea of what most people do this for, is shortage of work, which is usually evolves into a layoff, which eventually turns into a permanent layoff, which we'll be discussing later. Economic reasons, the employee simply not being a good fit, or in the cases which we discussed in the last slide, you have a good case, to try and terminate the employee for cause. At least you believe you have to have a good case, but you've been advised by your HR prime consultant that you have not reached the bar of willful misconduct. In a case like that, terminations without cause are absolutely the safer road. So as much as I started this slide by saying you do not need a reason, there are always those exceptions to the rule, which is basically can be summed up as employee rights. So the reasons you can't, and we're going to go through each one briefly because they're important, is if you have a collective agreement or you have a private contract, even if you're not union. Those types of things typically specify, private contracts typically specify the reasons why a termination would be merited with cause or a separation without any payment. Certainly collective agreements, most well-written collective agreements are detailed to that accord. So those are things you have to keep in mind if you're in a unionized environment or you have a private contract, more over and above what the ESA standards are. Protections afforded by the Employment Standards Act. So a good example of reasons why you cannot terminate somebody is if they're coming back from mat leave or you suspect that this person may go on mat leave. That is a protection that's afforded by the Employment Standards Act in every jurisdiction. It's a reason why you cannot terminate even without cause. Health and Safety Acts, Workplace Safety and Insurance Board, Workers' Comp, all these provisions have reasons why you cannot terminate. So a really important thing right now is work refusals. If someone refuses to come back to work and they do so on the basis that they feel your workplace is unsafe, there's a process for that. But if they refuse to come back to work and they say your workplace is unsafe and you simply fire them at that point, that's something you cannot do. You have to follow the process, which is outlined in the Health and Safety Act. And if you don't, then they are given protection against reprisal. Human rights, and human rights is the one where I know a lot of my clients are on this call, so you're probably used to hearing this and just shuddering at this point. Human rights is the one arena where if you're going to terminate somebody, it's going to cost you a lot of money, win or lose. So if someone takes you to the Human Rights Tribunal, you have to have representation. Representation has to be professional representation. Professional representation isn't expensive. Even if you win, the average cost of someone representing themselves at the Human Rights Tribunal can be well over $10,000. So you have to be mindful whenever there's human rights considerations in play. And by human rights considerations, I mean, has the person had a recent disability? Is the person a visual minority and there's something in the workplace that would provide a stigma that may lead to a conclusion that the person's termination had something to do with the fact that they are a minority or a protected status under the Human Rights Code. All these things need to be considered, and it's really important because that's where, if you err and it's going to cost you, the human rights arena is where it's going to hurt. And finally, other considerations that you have to have for terminations without cause. The message in the letter, I consider to be one and the same. As much as you do not need a reason to terminate without cause, and again, my clients will know I'm a broken record on this. If you do not have to provide a reason, do not provide a reason. Simply saying the company has looked at their future obligations or their future business plans, and we just don't see this arrangement as a good fit for either party going forward. You could be terminating them because they're just a jerk employee. You could be terminating them because they have 5 violations and they have not met the bar of willful misconduct. None of that goes in your letter. None of that is said to the employee. This is a business decision. It's not an emotional decision. It's not a time to make your point. You pay the person what they're owed, which we're going to get to, and you let them know that they simply weren't a good fit, and you walk. That's the benefit of terminating without cause, is that you do not have to give a reason which the employee can come back to you and say that's not true and sue you for wrongful dismissal. Once you put something in a letter that is termination without cause, that is a reason for their dismissal, that is something they can take you to court for and say that didn't happen. That's the reason I got terminated. I want more money. So be mindful of that. The other thing too is the follow-up. So this is really important. I've actually unfortunately had clients come to me this way, and I've had former clients that have done it this way. The follow-up's important. The messaging you provide to potential future employers, to your existing staff, when someone is terminated without cause, it is none of the business of anybody else in the plant. I know it's a difficult circumstance because sometimes the hardest part about terminations without cause is the morale of everybody else around you. But it's important that you note that this person was simply let go. It wasn't a good fit. That's the company line. That's all you say. If you get somebody called for a reference, same thing. If you tell them there was a reason why that person was terminated and they are denied the job, they can sue you. So be mindful of that as well with terminations without cause. So terminations via layoffs, and this is quite frankly a game changer with the recent legislation that's come into play. So it still remains that if you lay off an employee, that you could face a claim of constructive dismissal. And we're going to get to that in a second. Essentially, what we're talking about is if you do not have something in your employment agreement that allows you to lay off an employee, then that is a meaningful change to the employment agreement, and that can result in constructive dismissal, because it's not a reasonable expectation, especially for white collar workers, to be told that we no longer have work for you. So recently, the Ontario Regulation 22820 amended the ESA. So what you see up on the screen right now, it's still the way the ESA is written, that an ESA provides for temporary layoffs that may last up to 13 weeks or 35 weeks if in the latter, the employee was provided benefits. This is what has been temporarily amended, that at the end of either of those periods, the employment relationship would be considered terminated, regardless of whether or not the employee wanted to do this or whether the employer wanted to do it. At the end of the 13 or 35 week period, the employment relationship would be terminated and all termination obligations would be forthcoming. The new regulation means that now people that have been laid off due to COVID-19, they are considered to be on the infectious disease emergency leave, and they continue to receive EI. So what does this mean for you? This means if you have an employee that is on your payroll or wasn't kind of tentatively on your payroll, that is the 12-week mark, and next week you are preparing to issue the termination letters and termination pay, you no longer have to do that. They are no longer considered to be laid off. They are now on the IDEL, which is a protected leave. So you can, not only can you not terminate them in most cases, but you're not expected to terminate them. So for many employers, this is a relief. Termination pay, especially for longer term employees, is expensive. So for many employers, this is very much a relief for sure. For the people that have asked, my clients included, this period, everyone that was on layoff, they've been retroactively put on this leave. So it's as if the layoff, it's not so much that they changed the layoff legislation, it's more so that the layoff legislation doesn't apply because they're no longer considered to be laid off, they're on this leave. So this will continue, if you're wondering, it will continue to the end of 6 weeks after the Ontario state of emergency ends. So once Premier Ford declares that Ontario state of emergency has ended, people will be allowed to stay on leave for another 6 weeks, at which time you'll either have to bring them back or again, your termination obligations are going to kick in. Constructive dismissal. So this is when the employer breaks the contract. So I want to be very clear about, because for whatever reason, as much as most people have a generally good understanding of constructive dismissal nowadays, because it's kind of been a big thing in employment law and in HR, there's still a fundamental thing that a lot of employers don't understand. When you sign an employment agreement, that is in fact a contract. So just like it would be with your cell phone provider or your cable provider or the lease that provides you on your car, when you break that contract, you should expect consequences. Okay, so the terms in a contract, if you unilaterally change them, that is the same as voiding or terminating your contract. So an employer makes basically a definition, just so you can understand it, because just simply changing someone's contract does not make it constructive dismissal. Constructive dismissal is when an employer makes a meaningful, one, and two, unilateral change to the term or condition of an employee's agreement. So I had a call yesterday from a client who went to an employee and said that they needed to, this is in light of the new changes, so it wouldn't have made a difference, but went to an employee and said that they needed to reduce their hours in order to make this to keep afloat. The employee was very understanding of the employer's plight and actually agreed to it. Right there, that does not satisfy the second piece, which is unilateral. In other words, if the employee agrees to whatever changes you want to make, it can't be constructive dismissal. You just renegotiate your deal. The other part of it, which is more important, is meaningful. So if you were to say to an employee that, listen, you work in this office, but we want you to work in this office going forward. And even in their employment contract, they said they would work in office A. Moving them to office B might not be a meaningful change if it's only 5 minutes extra drive. But if you ask them to commute an extra half hour each day, there's a good likelihood that that employee may be able to take you down the path of constructive dismissal. So examples of constructive dismissal, a decrease in pay or position, meaningful changes to an employee's position. That typically occurs from a manager when you take duties away, or from a rank and file person when you start to add excessive duties without pay. Job changes to their status or authority, or a layoff, as we discussed already. So this is a lot of things. I put a post on it on our social media this morning. I had a discussion with our team about it yesterday. There's a lot of employers and employees who are still not aware that in addition to the changes made to temporary layoffs in the reg that was announced a couple of days ago, one of the other things that also was introduced was employers now have the right to temporarily reduce or eliminate hours, or a temporary reduction in wages under COVID-19, and it would not be considered constructive dismissal. For people in the HR world, that's a game changer. Even if it is only temporary, the idea that an employer can go up to an employee and say, yes, you work 40 hours a week for $1,000 a week, and now you're going to work 30 hours a week for $200 a week, it puts employees in a situation that, from an HR perspective, I do not think we would see from this government throughout this crisis. But nevertheless, for employers, it's going to provide a terrific relief. So what does it mean? So going back to constructive dismissal in general, when someone is constructively dismissed, that means they are terminated. You've voided the contract. So even though you didn't intentionally, in many cases, initiate the termination, all the obligations of a termination are due. One thing to note, and if you're a student of case law, you'll pick up on this. A lot of times, constructive dismissal is decided in the courts. If the court feels that somehow you taking away someone's duties, or taking away their status as authority, was a way to get that employee to quit, and not claim destructive dismissal, when they do make the award, it's been noticed that it will be more harsh. So you have to be mindful that if you do get in a case of constructive dismissal, you'd be wise to be proactive about dealing with it rather than it ending up in a courtroom. And finally, the way to mitigate your liability against constructive dismissal, obviously, is the language in your employment agreement. And the perfect example is layoffs. So if you have a term or clause in your employment agreement that says, in the case of poor operational or poor economic times, we have the right to temporarily lay you off as per the terms of the ESA, then you're fine. But if you don't have a clause like that, or a clause talking about changes in position, changes in, you might work at this site or the other, then you are subject to a claim of constructive dismissal. One thing you can do, even if you do not have the wording, is you can provide appropriate notice. So what does that look like? So when I say appropriate, when I say that terminations and constructive dismissal are the exact same thing, they are. And one of the things you can do when you terminate somebody is provide them working notice. Well, no different than when you change someone's terms of employment. If you want to change their pay and they've been there for a year, say, we are going to change your pay effective 2 weeks from now. That is providing, in essence, working notice. So whether or not they decide to leave, or whether or not they decide to take the decrease in pay, you provided them with a 2 weeks notice plus a week common law, which will significantly reduce or mitigate your liability. So I'm going to try and breeze through, because that took longer than I wanted. I'm going to try and breeze through the calculating of a termination package, because I know this is something that we're going to be doing a separate and distinct webinar on, and get this this content turned over to Steve and Matthew from the Leslie Group. So one of the things that I tell people is I like to use the word termination package and not severance package, because in both Ontario and for federal legislation, severance is an actual part of your termination package. So the three things that make up termination package is termination pay, which is either notice or pay in lieu of notice. In the federal government CLC or Ontario, severance pay, which in Ontario, for people that do not know what severance pay is, if someone's been on your payroll for more than 5 years and you have a payroll of more than $2.5 million a year, and you owe them a week for every year of service and partial year of service, up to a maximum of 26 weeks, and that is paid in addition to termination pay and, of course, common law. So if you have a longer term employee and you are a big employer, you are going to be on the hook for all three of these things, which is why you see termination packages for longer term employees getting upwards of a year, 2 years, and that bar has even been reached of late. So we'll get to that later. For the record, I'm not going to discuss termination pay and severance pay because they're relatively straightforward and that's something that comes through the ESA, but we are going to discuss common law. So what common law is, it's the theory of fairness. So common law is not employment legislation. It exists as a rule, and it's as a rule of the court, and it is subject to every jurisdiction with the exception of Quebec. I don't know if Maurice is on this call. Don't be offended, my friend, when I say Quebec is strange. So we don't talk about Quebec in our webinars unless we're doing one specifically on Quebec. So the fundamental principle of common law is to provide enough paid time to find alternative comparable employment. So it's not a reasonable expectation that if you hire somebody or fire someone that was making $60,000 in a professional job, that they should have to mitigate their damages by going to find a job at McDonald's. They are able to have a sufficient amount of time, which you will have to pay for via the common law award, to find comparable employment. And comparable employment means likely in the same industry, typically in the same geography, similar money, similar titles, similar power. So that's something you have to keep in mind when you're putting together your package. Factors that the court will consider: employees' years of service, age, position, salary, and the availability of comparable employment. The last point being a COVID-19 consideration. If you terminate somebody right now, you have to be familiar about the availability of comparable employment in that same industry, in the same geographic area. If you're terminating somebody right now and the availability of alternative employment in the specs I just mentioned are not high, if they're low, then you will find yourself having to pay more common law. On the other hand, if there is quite a good job market in your area, then you would have to pay less. It's important to keep in mind that there's no hard rules or outcomes. So as much as any of you can get on the phone with me or any one of the great HR consultants at HR Prime and ask about common law, we can rely on our 20, 30 years of experience and our knowledge of case law and what have you. But at the end of the day, there's no hard rules. One judge in two exact cases, one judge can give a different ruling than another judge even if all the facts were the same. So there's not necessarily a precedent. And there used to be what was called a implied 2-year cap on. So in other words, a common law package termination package would never exceed the 2-year mark. That has actually been breached a few times. The courts have pulled it back. So it's really uncertain about where the cap on common law is anymore. But the 2-year cap is still unofficially kind of where it's at. Finally, you can mitigate your liability with a very well-crafted termination clause as part of the original agreement. So I tell my employers the most important document you'll ever have in an employment arrangement is the employment agreement. If you haven't had it done professionally, give us a call. We will help you with that. So I believe this is my last slide, and I'm going to be brief on this one. When you're doing when you're presenting a package, negotiation is key. So if you're not comfortable with the concept of negotiation or good at it for that matter, it's wise to trust a professional. It's important that you be reasonable to start. So if you end up in a court and at the end, and when the court reads what the judge, because whatever your first offer is going to be, is likely going to be what's going to be on the table when you end up in a court. If that offer wasn't reasonable, the court will prejudice against you. So you need to, because quite frankly, and I can explain this to you better from the words of a very senior labor lawyer that expressed this to me many years ago. If you're in front of a court because you offered a crappy package, then the court's going to viewing you as wasting their time. So if you're wasting their time, at the end of the day, they're going to punish you. So be reasonable at the start. Know your opponent. This is going to sound awful, but it's, from an employer's perspective, it's important. You need to know a little bit about the person that you're negotiating with. So if this is a person that has money, comes from a wealthy family, things of that nature, the likelihood that they would have the money to take your offer and challenge it in a court is high. If this is a person who is highly vindictive, if this is a person who has a chip on their shoulder, the likelihood that they would take your proposal and say, shove it, and see you in court is high. All the opposite is true as well. And that's, as much as it's a thing that people don't want to talk about, leverage is something that is important in all negotiation, even when it is the termination of an employee. And never give money without securing a release. I know one of my clients is on the phone who we had this talk yesterday. Whenever you're giving out something extra, get the release. There's no, you could give somebody an extra week, they could take it, and if you don't get the release, they can still take you to court. So basically you gave them an extra week. When you give anything, if you owe them 2 weeks and you give them 3, say, we'll give you these 2 weeks. The extra week is in exchange for this full and final release. And make sure you give the employee time to seek counsel and to, come back with an educated, informed decision. So as I said a few times throughout this process, negotiating a termination package can save or cost you a lot of money. So again, we're here to help. So on that note, I'm going to try and find Steve here, and we're going to turn to terminations for a non-union environment. Now, admittedly, I muted everybody. Oh, there you are. So Steve, you should be able to talk now, I believe. Just as in the way of quick introduction, I've been a chief bargaining agent for a municipality for over 10 years. So I can tell you what labor relations is and how challenging it is. Steve has been doing it for 30 years. He's a most welcome addition, both his knowledge and experience to our team. And he's absolutely the right person to be talking about this subject. So Steve, are you able to speak in? Hopefully you're unmuted.
Let's give it a try. Can you hear me?
I can, but you're echoing quite a bit, so you might have to turn your volume down.
How's that, Darcy?
It's a little bit better. Just try and run through it and see where we go with it.
Maybe move back a bit from the computer. Does that work?
Nope.
Okay, well, we'll do our best nevertheless. Thanks, Darcy, for the kind words and for giving me the opportunity to talk about a topic that's close to my heart and to a lot of other hearts as well. And also a warm hello to all those who are listening in on this webinar. And before I get into the differences, I'd like to suggest some helpful strategies for dealing with the unions. Clearly, there is a union and we have to deal with them, whether we like that or not. Hopefully it can be a good thing. So in terms of strategy, it's in your best interest to advise the union prior to the termination itself, even though there's no obligation to do so. It shows respect and the strength of the relationship with the union that will serve you very well going forwards. Oftentimes when you deal with people, it's all about the relationships, right?
Steve?
Yep.
Sorry, my friend. We're having, I just had a whole bunch of panelists email in saying they can't hear you or can barely hear you at all. So what I'm going to suggest is why don't we table the slide for the purpose of clarity, for lack of better words, and then we can come back to it on our next webinar, certainly. Are you okay with that?
Yeah, I'm fine.
Okay, sorry about that, Steve. Just a technical difficulty, I suppose, folks. We apologize for that. So we're just going to skip through this slide. All great material, I'm sure. So at this point, I would like to thank Wages. Wages is, they are kind of a backdoor for employers, and they are a partner of HR Prime. We work with them closely. They will provide funding for your payroll. They will do your payroll, as well as, helping you find staff, retain staff, and administer. So we'd like to thank them for being a sponsor for our webinar. And now we're going to move on to the Leslie Group. Matthew is going to be joining us. Matthew, are you able to speak? Or are you unmuted?
Yeah, no, I'm here, Darcy. Can you guys hear me?
Yes.
Okay, perfect.
So I'll turn it over. Just in the way of quick introduction, the Leslie Group is a benefit provider for small and medium, benefit broker for small and medium employers. I've been happy to have a relationship with them for the last 3 or 4 years. They share the same customer service ideals and support of their client. And I'm pleased to present Matthew, who's going to do a presentation for us around terminating employees and what that looks like for benefits.
Perfect. Thank you very much. Darcy, can you switch to the next slide? Perfect. So as Darcy kind of said, I just want to talk about managing the process when you're terminating an employee. So, Darcy had some great information, obviously, around consulting legal counsel and HR consultants whenever needed. But once you've decided you're terminating someone and kind of the process with that, we really move on to step 2. And a lot of things that a lot of clients aren't doing, unfortunately, is communicating with their benefits advisor, the insurance carrier, group retirement carriers, and third-party providers. When I say third-party providers, I'm referring to things like EAP programs or virtual healthcare programs or anything like that. Because really, when we're looking at terminating an employee, you want to make sure that they're coming off of all of those programs at the right time. And that kind of takes me to the next slide as well. The big thing is when you are terminating an employee, regardless of any sort of severance, which I'll get to in a second, you really do want to check the carrier bill after you've processed those terminations. It's an unfortunate reality, but insurance carriers are not always the best at updating billings. And I'm sure many of you have probably experienced that in the past, unfortunately. We have been successful typically with getting premium credits retroactive to about 3 to 6 months. But really, if you have someone that continues to be billed on that program for an extended period of time, you could be liable for the additional premiums there. When it comes to calculating severances and if you're including any sort of benefits continuation as part of a severance package, a big area of caution is that you do need to get any sort of extensions pre-approved by the insurance carrier. Otherwise, you could be liable. So if you've promised something to an employee and the insurance carrier has not agreed for whatever reason, you could be on the hook for that. So just be cognizant of that. And I always joke with clients as well, like just because a lawyer tells you can do something does not mean you can. So I really do recommend, going through your benefits advisor or communicating with the insurance carrier directly to see what benefits continuation options you have. And when it comes to continuation of benefits, there's different things that need to be factored in. So, the conversion options or continuation options really do depend on the insurance carrier's terms. So double check your contracts. Again, check with your advisor and the insurance carrier to see what continuation options you have. When it comes to the specific member, they're going to base the continuation provisions on things like years of service, occupation, and job title. So if you've had an employee that's only been on staff for a year or 6 months or whatever the case is, and you're trying to offer them a 6 or 12-month extension of benefits, chances are you're not going to be able to do that. If you have an employee with longer tenure or an executive level position, we've seen approvals, up to 6 months is typically not an issue. Anything beyond kind of that 3 to 6 month period, depending on the situation, may require some additional supporting information to be provided to the insurance carrier. So again, that's where it's crucial to have your advisor involved, as they should be the ones assisting you with that. The other important thing to note here is that not all benefits can be extended. And that's a big misconception. So if you're putting into severance agreements that all benefits are extended for, X amount of months, just be cognizant that that doesn't hold true for all benefits. So disability and life waiver benefits would cease at the end of the ESA period. And then depending on the insurance carrier you're working with, they may or may not offer extension on the out-of-country benefits. The other important thing to note when you're terminating members is you do have an obligation as the employer to notify them of their conversion options for various benefits. And unfortunately, this is something that often gets missed when terminating an employee. Different benefits have different kind of conversion provisions, pardon me. So whenever it comes to life insurance, you do have the option to convert those benefits within 31 days of losing your coverage. And when I talk about conversion products, so I'm referring to a product where you can convert coverage on a non-medical evidence basis. An employee would always have the option to apply for individual coverage that is medically underwritten. Oftentimes that coverage can be more flexible and a little bit more cost effective, but it really does depend on the individual employee's situation and kind of their health status. Yeah, perfect. Less common conversion options would be around critical illness and long-term disability benefits. So again, this is really provider specific, but there are some providers that offer options around conversion for these benefits. So again, check with your advisor and insurer to determine which conversion options are available. The bigger one is around, and the more common one is really around health and dental conversion. So employees losing coverage have up to 60 days to convert coverage. Again, there's two options for this type of product. There's the medically underwritten option, which again is typically more comprehensive, offers better levels of coverage, and can be more cost effective if someone is in good health standing. If someone wants to go through the actual conversion product, again, there may be some restrictions, and it is important to note that any conversion product will not mirror the same contract that you would have on the group side. But again, there are some options there. I've already kind of covered this as well. So again, conversion options are non-medically underwritten products, and you do have the option to always apply on a medical evidence basis. And then just a reminder that you do need to inform them of conversion options as you're terminating members. On the group retirement side, it's a little more simple. You really just need to notify them or notify your provider or the insurer. And they'll actually send out a termination package to the members, giving them options for how to direct funds and what they can do with their group retirement assets if you have a plan in place. The only other kind of cautionary note here is just, make sure that the timing of the termination doesn't happen too soon. You want to make sure that any final contributions are received by the provider before you're terminating that member off the plan. Just a quick slide on the Leslie Group. So as Darcy said, we're a group benefits and group retirement consulting firm. We're located in Toronto. We have offices in Calgary, Winnipeg, and in Simcoe-Muskoka area as well. We work with clients, all industries, all sizes. So if you do have any questions, our contact information is on the next slide. I'd be more than happy to answer any of your questions. Thank you very much.
Excellent. Thank you so much, Matthew. That was terrific. You actually, some of the questions that we had sent in advance for the Q&A, you answered a few of them, which is terrific. Then you also brought to light another one that when we get to the Q&A session, which is coming up now, we'll address. But certainly, thank you for sharing that knowledge. That was super helpful and insightful. Look forward to you joining us in future webinars.
Thank you.
So we've reached the end of our formal presentation part of the presentation, and we're going to move into the live Q&A. So again, anybody who has questions, please put them in the Q&A field. It looks like there's about 9 there. So we'll try to do as many questions as we can. Before we get there, you'll see on the screen, and please do check out our platform. You'll see on the screen our 2 kind of keynote products that we offer. Our on-call support, it's $900 for the year. It's one cost. That's it. You can put your entire team on there. You get 5 free custom documents and discounts and everything else. So it's unlimited emails and call support. It's a very affordable product for what you get. So then of course our one code compliance. So when you start people up in Ontario, there's 5 or 6 courses they must take to be legally allowed to work here for $595 a year. You can have them take all those courses, as many employees as you have, unlimited for the year. So please take a look at that. We're pretty proud of our new platform, and we're proud to be showing it off here today. So I'm bringing up the members of our team. For those of you who have participated in the prior webinars, you've met everyone on here, including myself. And of course, there's our contact information, which I'm going to leave up while we go through the Q&A, but not before I understand Tar Heel's returned from his latest archaeological dig. So there he is. So Tar Heel and I and the rest of the team are ready to answer your questions. I'm just going to start to bring up the questions here and we'll get started. Oh, a whole bunch. Okay, so the one question that I wanted to address off the start, just because it tied in with the great information that Matthew had provided us, is that we have a client who offered an employee a package inclusive of salary continuation past the ESA. So the question was, are we required to pay benefits for just the ESA weeks or all of it? This is a common, I want to say in my experience with my colleagues, this is a common misnomer for some HR people. The theory of common law states that you must provide all the things that the employee had while they were working. Most HR people think that that's only in the ESA period, where in fact the theory of common law demands that if you gave an extra 8 weeks past the ESA period of common law, and you did that in the way of salary continuance, everything they had prior must be continued on unless you specifically and in writing exclude it in the termination letter. So the way you write termination letters when you're doing common law is incredibly important. Be sure that you're aware of that. Otherwise, you're going to be on the hook for everything. And moreover, as Matthew said, your benefit company might refuse to go past the ESA company if you don't seek previous approval. So you might be on the hook for equivalence of the premiums. So we're going to go through some of the questions we have here. So one of the questions from a participant, an employee has already served notice through their legal counsel that they are suing for wrongful dismissal. This happened prior to the last regulatory change. What happens to us in that case? So great question. And there's another similar question that was sent in. Anything in the way of terminations or anything of that nature that happened prior to May, I think it's May 29th, which was the date the legislation became enacted, stands. So if you terminated an employee before May 29th, that termination stands. There is one exception to the rule. And sorry, just to follow up on that question, in addition to that, obviously, if there was a recourse, someone suing their employer for wrongful dismissal beforehand, that would stand as well. So in addition to that, the one exception to the rule is if you have somebody that, let's say you terminated them last week before this legislation came to be, and you literally have them on working notice. If the employee and the employer agree that they would like to reinstate employment, and if that meant them going on the leave thereafter, so be it. But if the employer and employer agree to that, you can actually reinstate the employer and the employee's employment. Determination would be considered void, and that person would either start to begin to work again or be placed on the leave. If the employer or employee don't both agree, then the termination stands. Okay. Next question. Can you please discuss this is from Martin. Can you please discuss the inclusion of outplacement services during these challenging times for people being terminated? Outplacement service, much like EAPs, this is just an HR observation. I've always found that HR outplacement services are beyond benefit to people in the most vulnerable time, which is when they're being terminated and are without income or a job. So I always considered outplacement services in many ways to be the extension of an EAP. So you have your EAP, which takes care of you and is there for you in the case that you should have a crisis or an event at work. Well, what happens to the biggest crisis of all, which is, of course, you being terminated? So yes, Martin, outplacement services are invaluable. If it means anything for those people out there that are materialistic of the bunch, when you do provide an outplacement service as part of a package, that helps mitigate your damages, because some outplacement services are designed and will assist you with finding alternative employment. So often when you'll see clauses that say, if you find alternative employment, you only get this much. That often is looped in or coupled up with an outplacement service paid for by the employer. So excellent question. Joel, will this recording be? Yes, this is being recorded, and it doesn't get sent out to participants, but it will be hosted on our website. So if you go to our website, www.hrprime.ca, and you click on the webinars tab, every single webinar we've done to date is recorded, which includes the live Q&A session that we're doing now. For termination with cause, how much can we reveal if we get called for reference checks or for internal communication letter? So that's a really interesting question. It's semi-quasi legal. So at the end of the day, I encourage, because why would you put yourself in a libelous position when you do not have to? I encourage my clients, when they get a call, termination for cause, that they simply say that the person was terminated for cause and leave it at that. You're not required to provide details. Technically you can. You're not doing, if you've terminated somebody for cause and you want to provide specifically and only the reason, if you said breach of trust, you could technically say that. I highly discourage you from doing so. Simply for saying that the person was terminated for cause typically is enough, and it's usually just a confirmation that the other person on the line is looking for. So do we have to communicate to formerly laid off employees about the IDEL change? It's not required by the legislation, but good business practice suggests that you should. Okay, and do we need to amend the ROE from the layoff to the IDL? That's a good question as well. It was a question that I received yesterday, so I did some research on it. Could not find an answer, which to me, when there's no change in the actual messaging coming out from Service Canada or the government, that would mean typically that it's status quo. So I'm going to suggest that because the change is automatic, if someone was on a layoff prior and then automatically put on the IDL, that an ROE wouldn't be required. I find it hard to think that with the stress that these folks at Service Canada are under right now, that they would go to the length of telling employers that they have to submit an amended ROE. So that's the best answer I can provide. Hopefully that works. If we have employees on layoff currently, and we do not bring them back at 13 weeks, we don't have to terminate them and pay out termination pay. Question mark. That is correct. When the state of emergency ends, we as employer pay out termination pay at that time. And again, hopefully that answer was answered for you in the presentation. But to reiterate, 6 weeks after the date of 6 weeks after the state of emergency ends, that's when your termination obligations will kick in. So the hope is that, kind of doing a crystal ball thing about what they were thinking when they did that, is that the end of the state of emergency, that would suggest that we're in a better place. Within those 6 weeks, the hope is employers would be able to bring back their workers, or at least at the end of 6 weeks. If not at the end of that 6 weeks, then it is assumed that your termination provisions would again kick in. Okay, for Reg 22820, does this apply to all jurisdictions? What happens after the COVID-19? The O in Ontario, the O in O Reg 2, that's for Ontario. So I apologize for that. I could have made that a little bit more clear. Another question, you mentioned protection afforded by EA, but if someone is coming back from maternity leave, but there's a shortage of work for the role and they're returning to, or if the role is no longer available, COVID-19, such as receptionist, office manager, as there is no longer an office, can you terminate without cost? Okay, so one of the exceptions, so you should know, if a business closes outright, they're not protected from the termination provision. So that also means that the employer is obligated. So if your business is closed outright, then in a case like that, the employer has, if it's a smaller employer, has termination obligations that they must abide by. And if it's a larger employer, then they're going to have mass terminations conditions that they have to abide by. So if it is if it's a case where your business is closed outright, regardless of whether you're returning from mat leave or what have you, regardless of whether you're on the leave of absence or whether you're on layoff, all termination obligations kick in as soon as the business closes. Does one's family situation, question mark, size of family play a role in common law decisions? Technically, no. I've heard it argued. I've been in courts, been in numerous courts where it's been argued, the role of common law. Technically, it's not supposed to. It's not one of the factors that is consideration for you getting alternative employment. What it is a factor for, however, is kind of fiduciary. And this is just common sense, really. If you consider someone with a larger size of family, the idea that they might be able to move for alternative employment is less likely. You would be disrupting the kids, things of that nature. So in a case like that, you could make a lawyer or, an HR person on your behalf could make a fiduciary argument that you have a large family, so the options available to you are more limited. So that's certainly a consideration. So I'm also, though, to be fair to the people that emailed in, I'm also going to answer some of these questions. We have a couple of minutes late, and we said the webinar ends at 12, but I'll try and answer as many questions as I can. And forgive me, typically I like to kick this back and forth to the team for questions and answers. It's just we have a whole bunch of questions and not a whole bunch of time, so I'm trying to be as thorough as possible for the benefit of our participants. So I'll try to answer as many questions as you can. If you have to go, I understand. Thank you for joining us, but we'll keep on going. So we had an employee leave who borrowed and used a week of vacation. We took the money off of his final check, and we received a letter from a paralegal representing him saying we had to pay it back. So just so you know, that person didn't have to use a paralegal. They just had to go to the Ministry of Labor, and the Ministry of Labor would have did it for free. And the Ministry of Labor would have told you the same thing, that you have to pay it back. Even though that person in your eyes might technically owe you that week's vacation pay or the money relative to the time. In fact, you cannot deduct money, with a few exceptions, from people's wages or people's paycheck without express written permission. And the permission, the form that you would have them sign, would have to have the reason you're doing it, the date that you're doing it on, the exact amount you're deducting, and it would require the employee's signature. So short of that, the only way you're going to get that money back is in a court. And unfortunately, and I hate to say it just this way, the likelihood of a court giving you your money back for giving somebody vacation time in advance is close to zero, unless you had some type of specific policy about borrowing. The ESA is set up in Ontario, is set up in such a way that it's a pay it forward system. So what I mean by that is, for the first year of employment, you're not required to give an employee vacation time. They accrue vacation pay, but the vacation time is banked and you're not required to use it. So in the second year of employment, they have 2 weeks of paid, if it's a minimum, 2 weeks of paid vacation time and pay ready to use in the second year. So they'll never have to borrow. If it's your decision, and it is the decision of the vast majority of employers to provide somebody with the opportunity to take vacation in advance, so give them their 2 weeks at the beginning of the year and let them use it, and they use it and then they leave, that's on you, unfortunately. You're being a nice employer, but still, at the end of the day, it's on you. So we've offered somebody a termination, and we did so with an end date, and it included common law, kind of paraphrasing this question. They have not got back to us by the end date. What do we do? So first thing, obviously, is to reach out to them. If they're using legal counsel or a representative, then reach out to the legal counsel or representative. There's no harm. I'm very much an advocate of the day before something like that will come due to reach out to them, ask them if they have any questions, ask them if they have any concerns, see if there's anything you can do to help them. Oftentimes, this is a confusing and stressful time for them. And a lot of times it's just they didn't realize that the deadline was tomorrow. So it's wise to reach out to that person and find out if in the end they either do not respond to you or simply say they're not going to sign it, then you are required at that point to pay them their common law amount, or sorry, begging your pardon, their statutory amount. So if they had been employed for 2 years and you offered them 4 weeks, 2 weeks ESA, 2 weeks common law, you are required to provide them at that time their 2 weeks statutory benefit. And then they're either going to come back to, they're either going to drop it, leave the money on the table. They're either going to come back to you and renegotiate, or they'll likely see you in court. So this is a question that was already asked. Here's another one that has not been asked. I have an employee who refuses to come back to work because she is worried it will expose her kids. We were considering our options, one being to fire her. Do the new amendments change our options? That's actually a really good question. Only because there's some gray area and uncertainty, because when you're put on, the new amendment says that everyone that's on a layoff is put on to a protected leave. So a protected leave means they can't be terminated. The caveat in this case is that's if they're on the leave because of their employer, right? Either that or they actually met the qualifications of the leave prior, which was they had COVID-19, they were taking care of somebody at COVID-19, they were home for childcare, et cetera, et cetera. So short of one of those two things, the recall rights of employers still exists. So as much as we're all dealing with this, if you're an employer out there and you haven't had this question yet, then you are incredibly lucky, or this scenario, begging your pardon, you're incredibly lucky that you have had not someone come and say to you, I don't want to bring it back to my kids. I have an elderly mother that lives at home. I don't want to have to take the bus because it's unsafe. All those reasons, while completely understandable, are not reasons to refuse work. So unfortunately for that person, the amendments does not protect them. You could still say, even though you're on the leave, we're still calling you back to work. They're required to come back to work, period. So just want to see a couple more questions. Okay, we answered that question already. I think we left most of, one last question I found here, and then we're going to call it a day, if that's all right by you folks. We have an employee who left us, they came back, and now we're looking at termination. How do we calculate what is owed? That's a good question. I can't answer it with just that much information, but I'll try and give you a scenario. So if you had somebody that left, and they left for, say, 2 months, and then whatever opportunity they went to seek didn't work out, they came back to you, you hired them back. That time prior to them leaving is almost certainly going to be considered in your termination package. There's a period of time where, and it's a continuance of employment, there's a period of time that must lapse, and it's not written in stone, it's more of a case law piece, but there's a period of time that must lapse before prior employment can be considered to be severed. So typically, if you look at the various things in the ESA, in Ontario and the ESA, that talk about severance of employment for different things, typically that period is 6 months. So if you have a separation of 6 months, then you could safely or more safely say that the period of time that they were with you prior does not count in the calculation of years of service to calculate termination pay. If it was 2 months, you're likely going to have to count it. The one exception, and this is a recent piece of case law, I think it was either 2 or 3 months ago. My brain is leaving me here. There was an exception where someone had been gone for 3 months, and because it was clearly noted that the employee left on their own accord for their own reasons, and there was no attempt by the employer that 3 months later to get them back, that constituted a severance of employment, and they were only responsible for calculating termination pay based on the time after they came back. So that was a good question. Thank you all. That was a boatload of questions. If there's any questions I didn't get to and the name's on the question, I'll respond to you in kind. I did want to put in one last little plug. All of you will be receiving a survey, basically asking us how we did. But the more important part of that survey is feedback about what you would like to see going forward. So we really try to get the pulse of our clients and our colleagues and our peers that are on this webinar today to see what it is that they want to hear about. But if there's a webinar that you want to know about, that you want to hear about, please fill out the survey, fill out what you're looking for. If we get something, we'll make sure that we include it. So last thing, our next webinar is going to be in 2 weeks' time, second Thursday for now at 11 o'clock. It's going to be about young and vulnerable workers in the workplace. We are quickly coming up on the summer. So universities and colleges have already started, university and college students have already started getting jobs. So now we're at the point where high school students will be doing the same. So it's important that you as an employer are aware of the special obligations you have for young and vulnerable workers. Our two health and safety dudes, experts as it may be, Dan and Chris are going to be hosting that webinar. I'm super excited about it. So hopefully we'll see you all there. On behalf of the entire team, thank you for participating and joining us today. Stay safe, and we'll see you in a few weeks' time.